This morning we are going to hear arguments starting with the case of City of Akron versus versus Brandi, Pasco, and Robert Perry. Case numbers 29029, 29030. I noted that counsel for Ms. Pasco concurred in Mr. Perry's brief. Are both of you going to be arguing, or?
Yes, Your Honor.
And how would you like to split your time then?
Your Honor, I intend to give just a very brief introduction and then turn it over to counsel for co-appellant.
Okay, very good. Each party will have 15 minutes to present their arguments. The appellant, of course, may reserve up to 5 minutes for rebuttal. If you would like to reserve time, just let me know and I'll keep track of that. Let you know as you get close. The arguments are being recorded and they are posted on YouTube, so make sure you stay at the podium and keep your voice up. We've read your briefs and are ready to proceed if you are.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. I would like to reserve 5 minutes of my time for rebuttal.
5 minutes, sure. Thank you.
This is a consolidated appeal. Here, there are two cases, two defendants, but there's only one legal issue. And the legal issue is, did the trial court err when it expanded the scope of the immunity provided for under 2925 B2B beyond its express terms and beyond the intention of the General Assembly to include other crimes other than minor drug possession offenses? The defendants in this case both have charges for, I believe, drug paraphernalia and possession of drug abuse instruments. They are not charged with minor drug possession offenses. That's defined under the statute of 2925-11B284 as offenses under this section, 2925-11, that constitute misdemeanors or felonies of the 5th degree. Drug paraphernalia, drug abuse instruments, they're not in 2925-11. They're not in the section that minor drug possession offenses uses as the basis of its definition. And the immunity provision of 29B2B only applies to minor drug possession offenses. So it only applies to drug possession offenses as it under 2925-11. The trial court was bothered by this result and said, well, that doesn't make any sense. I want to do it that way. And I think that the General Assembly didn't mean to do it that way and came out with different results used under the guise of the absurd result doctrine. The trial court's decision...
Of course, it would be consistent with the obvious intent of the statute, wouldn't it, to allow people to encourage people to call to save lives and not fear incarceration or arrest. That would be consistent with the court's rule.
It would be inconsistent with the language of the statute, which is what governs the actual intent of the legislature. And in this case, the legislature not only said it only applies to drug abuse, it only applies to minor drug offenses. It then went and said the opposite in 2925-11B2E, where it said, notwithstanding the rest of this, nothing in this section shall be construed to limit the collection or admission of evidence related to any crime that is not a minor drug possession crime. So the legislature not only was expressing what it was applying the immunity to, it went out its way to try to avoid having people look and say, well, I think we should expand this by saying, no, we definitely intended this only to apply to minor drug possession offenses. And that's what it did in 2925-11B2E, was it said expressly, this only applies to drug possession offenses. You can collect evidence, you can admit evidence that you collect as a result of these calls for any other crime that's not a minor drug possession offense. And while the Supreme Court has said you can use absurd result doctrine to avoid absurd results, the court has also been very clear you can't ignore the plain and express language of the statute in order to avoid the so-called absurd result. In this case, the language of the statute is clear about what the General Assembly intended. They made a policy decision that they only wanted to apply to minor drug possession offenses. And they went out of their way to make sure that that it was both in the affirmative about what it applied to and in the negative saying it doesn't apply to anything else. And they made a policy decision. The General Assembly is the policy-making body.
So council, I realize you're not in their minds,
Mhm.
nor are we, but what would be the point of the section that you are relying on? Show their specific intent.
29.5E, like, sorry, I know there's a huge number of numbers here. You're talking about the one where they allow 20,
They
more.
specifically say nothing in this section shall.
Right.
What's the point?
I think the General Assembly intended to avoid what happened here in the trial court. They intended to make sure that the trial court couldn't, under the guise of ambiguity, they say, well, it probably should have applied to everything else. They said, no, we want to make clear why it only applies to these.
But then let me take that one step further. What's the point of having this statute when, for the most part, it's directed because of the problem with opiates? I think we'd probably all agree with that. Heroin is injected. You're probably going to find a hypodermic somewhere around. Or are we encouraging the caller to now dispose of evidence before the police or paramedics get there? And again, I realize you're not in their heads, but I'm wondering, what's the point?
Well, I think that, number one, all the crimes associated with drug paraphernalia and drug abuse, to the best of my knowledge, are misdemeanors. They're not felonies. And I believe that the opiate would be a fifth-degree felony, which, so inherently they're limiting the, you're not going to be charged with a fifth-degree felony for the drug abuse instruments, I don't believe. And so that's why, so the charge would just be lesser, regardless. Furthermore, I don't know what other extent convictions for possession of drug abuse, possession of just drugs, has a wider ranging effect, possibly, than what a conviction for drug abuse instruments or drug paraphernalia do. Maybe with the way someone is, when they do background checks, maybe for deportation purposes, there may be extensions where the drug paraphernalia and the drug abuse instruments wouldn't be giving them problems, but the drug possession itself would. And so I don't know all the policy reasons why they made the decision they did, but they clearly intended what they did here, and I don't know why. The statute doesn't say, and the plain language of the statute is all I have to go on, and that's.
Appreciate that, thank you.
And this court has held that the language of the statute is plain, it is unambiguous. It was decided 3 weeks ago in a different case. The absurd result doctrine wasn't an issue in that case, I don't believe directly, but the Supreme Court has said you can't ignore plain and express language just because that requires the so-called absurd result just to under the absurd result doctrine. And the city would respectfully request that this court apply the statute as written, apply the plain and unambiguous language, and reverse the decision of the Akron Municipal Court. If there's no further questions, I will sit down and reserve the remainder of my time for rebuttal.
All right, you'll have your full 5 minutes for rebuttal.
Good morning, Your Honors. Becky Sremack on behalf of Brandi Pasco. I intend to give just a brief introduction and then turn this over to counsel for Robert Perry. At the outset, I will note that the facts here are not disputed, and this falls exactly into the intention of what the legislature put in their statute. That is that my client called for 911 for help for a drug overdose. Per statute, the 911 dispatcher has to state that there is immunity for drug overdoses. That is something that is required because the legislature is intending that people know and feel free to call for medical assistance without fear of criminal prosecution. Accordingly, both of the defendants in this case acknowledged that there was heroin present, which in fact turned out to be fentanyl. What was found on the scene was a spoon and a hypodermic needle. By themselves, these items are not illegal. It is only because they were around and they were being consumption of drugs, that these items then took on the character of being contraband. Would respectfully note for this court that Mr. Perry did receive the medical attention that was requested for him, and both parties believed that there would be immunity. However, their words were then used against them, and the absurd result came about, which was that they were both charged for the paraphernalia here. We believe that the statute does in fact encompass these drug paraphernalia and drug abuse instrument charges from the standpoint that these were used for drug consumption, for the possession of drugs. These are how the drugs, how fentanyl and how heroin are used. Clearly, the legislature intended that these acts would not be criminalized, or would respectfully ask the court to affirm. With that, I will turn it over, if there are no questions.
Good morning. May it please the court, I'm Susan Manofsky of the Legal Defender's Office, and I represent appellee Robert Perry in this case. The legislature took some extreme action to stop horrible epidemic that has touched more lives than we can ever know. What the city is asking you to do is to believe that our legislatures sat down and plotted out this plan where they would have innocent people calling for help and being told by the government that they are immune from criminal consequences. That is not what our legislature does. And if it is what happened in this case, if you decide the city of Akron is correct and that the Ohio legislative branch sat down and plotted out such a devious and deceptive law, then that law should be found unconstitutional. And there will be no immunity. And there will be no Good Samaritan law. There will be no reason.
The legislature decided when they drafted the law that whether or not to charge for the paraphernalia would be a matter of prosecutorial discretion.
They actually didn't specify that in the law. There's no discussion in there about prosecutorial discretion. But I understand your input.
There never is, right?
Correct.
Because the
I
prosecutor's in
understand
the
your-
executive branch.
I understand what you're saying. But I disagree, because if you look at the law for possession of controlled substances, and I appreciate that you recently ruled in the Jennifer Brown case, I just still respectfully disagree. It is ambiguous, and here's why. Possession of a drug does not mean you have it in your pocket. By definition, possession means to obtain it, possess it, or use it. If you throw out the drug paraphernalia when you are applying immunity for the use of an item, that's absurd. And that makes it ambiguous to the reader. How do I use fentanyl? How do I use heroin? How do I use crack? How do I use these items if not with drug paraphernalia? And as co-counsel has reviewed with you, those items in and of themselves are innocent. It's not until the drug is used that those items become criminal. And whether or not it's a felony or a misdemeanor, it is a serious event to the person being charged with the crime. I don't believe the state legislature intended to mislead the public. I do believe that we here now have the opportunity to correct what is ambiguous about the statute and what is unfair. And I don't have anything else to say if there are no questions.
Doesn't the statute use the word possession? A person should not be arrested for a minor drug, not minor drug offense, minor drug
Yes,
how possession of drug paraphernalia is a minor drug possession offense.
thank you, Your Honor, thank you for bringing that up. Drug paraphernalia is a minor offense by statute. It is a drug offense because the paraphernalia is not criminal without drug use. So it is a drug offense. And it's a possession offense because you are only guilty or charged with a drug paraphernalia crime if you possess it. So using normal, everyday Ohio citizen words, drug paraphernalia is a minor drug possession offense.
Does the statute actually define minor drug
Possession
possession
offense.
offense?
What the statute does, Your Honor, is it has a section. And drug paraphernalia falls within, was it the section or chapter? Falls within that. Now, granted, the legislature identified minor drug possession offense within the immunity section. And I believe they did that to make it clear to include certain felony drugs, not intentionally to exclude the items you use to use the drugs. It was not a definition intended to exclude anything. But because they were using the term minor in a way different from what you and I might consider when looking at statutes and whether something's a misdemeanor or a felony, it was incumbent upon them to identify, we are including these particular drugs that otherwise would be a felony in this immunity. That was the purpose for that. That is a logical purpose for that.
Couldn't they just have simply added the word paraphernalia or 3, 4 words that say, and the paraphernalia used?
Yes.
But they didn't.
So, they didn't.
Right or wrong, you know, whether we agree with that or not, they said what they said. Aren't we, as a court, supposed to infer that they had a reason for what they said?
If it weren't for all the other problems that make it ambiguous, I would agree with you. Thank you for your time, and I hope that you will consider that this law is flawed, and rather than throw the baby out with the bathwater, take the opportunity to give some guidance as to what this immunity includes. Thank you.
And you'll have 5 minutes for rebuttal.
Thank
Mr.
you.
Attorney Brandi.
Thank you, Honor. I just wanted to touch on a few points here. First, the constitutionality of the statute is not before this court. The trial court never got to that issue. They only decided to serve resolved. So that's outside the scope of the appeal, that portion of their brief. Also, this court has held the statute is not ambiguous. It's only ambiguous when defense counsel misuses the word section. It's not a section of 292511. 292511 is the section. It's a division of 292511. It is B2B. If that's the consistent term throughout the Ohio Revised Code for what the subsections of a general section are. So it's not ambiguous terminology. It's very clear about what the General Assembly was referring to. Also, there were easy fixes to this if they intended to do something beyond what they said. They could have mentioned the drug paraphernalia statute. They could have mentioned the drug abuse statute. I believe they're the next 2 statutes in the code, 12 and 13. They could have easily just said, or an offense under 292511, 292512 or 292513. They didn't do that. And they defined it as a minor drug possession offense, which is an offense under this section, which is 292511. Therefore, the General Assembly was very clear, it was very plain, it was unambiguous about what it was trying to do. And the other thing that has come up repeatedly throughout these cases, and I've never seen an actual citation for it, is the idea that the dispatcher has to inform the public about this immunity. I have not seen, they've never cited any case law, any statute for that proposition, and I have not found it myself. Therefore, I don't see what it's not that people are being misled, they're not being, and also they're told you get immunity for drug possession. You don't get immunity for everything else. That's not what they're being told, even if they are being told that. So there's no misleading of the public, and the idea of this is innocent behavior, it's not innocent behavior, it's a crime. You just have immunity from the crime. Immunity means that there's a crime being committed, but you're immune for any number of different reasons. And in this case, the reason is you call 911 or have someone call 911 for you. And so this is not innocent behavior, this is not making criminal something that's not criminal. It is criminal activity that the state legislature carved out a small immunity for. And with that in mind, the idea that this is nefarious or something like that is just not true. It was an act of compassion by the legislature, but it's a very limited one. The other issue I wanted to touch on briefly was the trial court relied on State v. White, which was the Supreme Court analyzing the firearm specification statute when
We have
it
2 minutes, by the way.
when it came to the absurd result doctrine. In White, the Supreme Court said the firearm specification for sentencing enhancement is not intended to apply to law enforcement officers who discharge their firearm during the course of their on-duty practices. And in that case, it's different than this case because, number one, it didn't have an equivalent of 2925.11b2e that expressly said, notwithstanding the foregoing, we mean what we said. There was an empty space there where you could make the argument it should apply to law enforcement officers, and you can make the argument it shouldn't apply to law enforcement officers. Essentially, they made the decision that it was an ambiguous statute and then went ahead and interpreted it based on the idea that law enforcement officers are required by law to apprehend criminals. Sometimes they require discharging a firearm or brandishing a firearm, and if they make a mistake about that, they shouldn't get the firearm specification because that would be absurd where they're choosing between two different crimes. And there's no way, and the purpose of the firearm spec was to dissuade people from carrying firearms. Law enforcement officers are required to carry firearms. And so White was a different set of facts. It was an ambiguous statute, and there was actually a choosing between two different crimes when they were looking at the analysis of how the law was laid out. And it didn't have express provision similar to 2925.11b2e. If the firearm specification had said this applies to law enforcement officers, that would be equivalent to this case, but it didn't say that. And so the court's reliance on White was misplaced. And for all the foregoing reasons, I respectfully ask this court to reverse the decision of the Akron Municipal Court and apply the statute as written and remand the case for further proceedings.
All right, thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to counsel on the day it's released, and also the opinions are posted on the Supreme Court of Ohio's website. So thank you for the excellent argument.